Good morning, Your Honors. May it please the Court. My name is Helen Nicole Heimbaugh from the Washington County Bar. I'm here on behalf of the defendant appellant, Robert Leroy Littleton III. And can you hear me okay?
I was just going to ask if maybe you could speak up a little bit.
I certainly can. Is that a little better?
Thank you.
Okay, thank you. Just remind me, please, if I'm not speaking loud enough. First, I would just like to say that I won't reiterate everything that I've mentioned in my brief. I would just like to describe the setting of the custodial interrogation that occurred several years ago.
There, can you say your name for me again? And
My
can
name-
you hear us?
Sure, it's Helen Nicole Heimbaugh.
Heimbaum?
Heimbaugh.
Ball. Ms. Heimbaugh, I don't know, I've not seen you in our courts before, but you know that we get a limited view of the record before coming in here. You know much more about the record than we do at this point. Can you tell me, I tried to look a little bit, the record is a little out of sorts, and the burden is on the defendant to have a proper record. Can you tell me a little bit about what is going on with the record or why it's so out of sorts? Specifically, what I could not find was the motion for new trial, a copy of your motion to suppress. I wanted to see exactly what the issues were that you raised before the trial court. Could you speak to that, please?
I'm perplexed why the motion to suppress wasn't included, but the motion to suppress was handled as a pretrial matter, and essentially we requested that the statements made by the defendant during the custodial interrogations when he was first arrested for this crime should be suppressed because he didn't make a voluntary statement.
Okay. I understood that from the transcript. We do have the transcripts. We just don't have your motions. We don't have your, I think it's the motion for new trial, which is the most troubling.
Okay.
You don't know anything about that.
I know that
I'm getting that from your facial expressions. I'm sorry. You didn't say that, but
I don't, but I know that at some point the clerk was unable to locate some of the pleadings and found them later and supplemented the record, and I thought they were included with that supplement.
well, we still do not have the motion for new trial, and that's a problem.
Okay.
Unless you, I mean, I'm certain you filed one, but you understand that sets the time rolling for us. So that would be a big problem if we don't have it in the record.
Okay.
But you don't know anything about that.
I didn't, but thank you for raising that
Okay.
issue, and am I permitted to file that?
I suggest that you do, if there's no objection from the state, that you file a supplemental record to include your motion for new trial.
I certainly will.
It needs to be a timely filed motion for new trial.
I certainly will. And I have a stamped copy of it from the criminal
great,
court, and
great.
I'll certainly file that.
Great.
And I know that some of the pleadings were lost in the clerk's office for some time. I'll certainly ferret that out.
Is that a normal thing with this clerk's office? I tried to look, I had more people look, and it was just really a problem trying to put things together to understand what happened in this technical record.
I think it was a new clerk
Okay.
who I don't think, my understanding was after a conversation with her, it might have been her first appeal.
Okay.
And
Okay.
this is a very small...
That's comforting to know, that it's not a normal problem, because
I
this
think
was
there-
really unusual.
And I think there were some mistakes that were made, and there were 5 co-defendants in this case, so I think the next appeals coming will probably be
Okay.
put together a little bit better, but this is a very small county in Johnson County, and I think there were many new staff members at that time.
Thank you.
So I can't speak to that, but thank you for raising that, and I'll certainly try to fix that if I'm able to.
You can go ahead and get to the substance of your issues.
Okay. Thank you. I'm a little nervous this morning, so forgive me if I read from my notes a little bit.
No need to be nervous. Go ahead.
The trial court in this case denied the appellant's pretrial motion to suppress his custodial statements, and the government relied very heavily on the what they would call a confession, what I would just call as a statement. And they relied so heavily in this trial that there were over an hour of the interview that was played in the opening and closing statements, and again relied upon very heavily throughout the entire trial, which I think was pivotal in the conviction that was obtained from the jury.
And we're talking about the first one, because there were 3 in this case, right?
Yes, Your Honor.
Okay.
And the first 2 interviews happened during the same time frame, and then the second interview was 2 days later, I believe. Or excuse me, the third interview was 2 days later.
You're really only focused on the first one. I want to be clear about that?
Yes, Your Honor.
Okay.
If I could just set the stage a little bit for the circumstances of this custodial interrogation. When Mr. Littleton was arrested, it was very late in the evening, and he was arrested in Burke County, North Carolina. And he was handcuffed, I think immediately, and put into the patrol car. His wife was also on scene, and she was also taken into custody. They were transported in separate law enforcement vehicles over an hour and a half away to Johnson County, Tennessee, across state lines. Mr. and Mrs. Littleton were in separate interview rooms. Mrs. Littleton was not arrested at that time, and Mr. Littleton was. He was placed in a very small room and handcuffed. There was 3 chairs, and law enforcement was on either side of him. And they were North Carolina officers who also testified at the motion to suppress. One of the officers was retired at that time, and so only one officer testified at the trial. That interview lasted for over 3 hours. I think it was around 3.5 hours. And he was made to sign a Miranda form, and it was a North Carolina form, and I believe it was the law enforcement's form that they had been using when they interviewed people from North Carolina.
You said he was made to sign it. Did he not voluntarily sign it?
He did sign that form, yes. Mr. Littleton did notify them that he had taken methamphetamine within the last several hours. I don't believe he noted specifically how long ago, but he did.
Is that a genuine issue? I mean, are you raising that he was in some way intoxicated or impaired during this interview?
We don't know, but he did express confusion.
I mean, I'm asking you, is that a genuine issue?
I believe it is, Your Honor, because he expressed confusion at that time. And
well, he spoke to the law enforcement officers for over 3 hours, and that's pretty extensive. That's a long time, and he gave varying versions of the story and didn't start expressing confusion until maybe the 3rd hour, after he confessed. I'm having a little bit of problem reading from the record and your briefs, inferring any intoxication from his comment early on that he had taken meth. That's my first comment. And my second comment is I thought, if I recall correctly, that he mentioned that because this was about a drug deal. This was about a drug deal gone wrong. Yes? And he told them that, yes, he had ingested meth, and the victim apparently, took him for a ride on the drugs. He gave him some false drugs or didn't give him drugs in exchange for the money that he gave him. So this is all related? Is that not a fair commentary on what's going on?
I think so. I would say, though, that I think it could have been cured very easily had they provided him with some type of sobriety test. But that being said, though, I think a cure could have been as easy as providing him with a drug test. He was on probation at the time. But I think that just because someone's on probation or has a prior criminal history, and that's sort of part of my next argument, is that doesn't mean that they're so familiar with being interrogated, what Miranda might mean, what signing a waiver of Miranda might mean. And so I think that if he had taken something as strong as methamphetamine, and we don't know how long or how much, and we don't have a measurement at that time, and there was plenty of time for some type of test to be administered. But I think coupled with any state of confusion, any level of impairment, the kind of duration that might have been, not being permitted to have a bathroom break, and then coupled with his desire and statement that he'd like his free phone call at that juncture, I think would
Well, all of those things occurred at different times over the 3-hour period. And the trial court didn't make a specific finding on impairment, because that's not really what you argued below.
Just the totality of the circumstances, I think, is what you were getting at.
Yeah.
I think that the length can cut both ways, though, in terms of over the 3.5-hour time frame. I think that could cut both ways. And again, just because someone has some experience with the criminal system, I don't think necessarily means that it might as go so far as to knowingly waive the kinds of rights.
Well, speak to me about what the trial court said. The trial court looked at his educational background.
He did.
And made very extensive findings on that prong.
His 2 degrees online.
Yeah, well, I mean, still articulate, wanting to talk to the officers, wanting the officers to engage him. Each time the officers attempted to leave, he came back and wanted to continue the discussion, because I believe they were still under the belief that the victim may be alive during the first interview. So the trial court made extensive findings on the defendant's knowledge or education in her order, correct?
Yes,
Yeah.
Your Honor, and I would just respectfully disagree with those findings.
I got you. That's fair.
In addition to some of the statements he made about, or Mr. Littleton made about being confused, he was unsure which towns were located in the county that he was arrested in. And so there were other indications of some confusion on his part. Some might argue impairment, some might argue confusion. I would just say that the totality of those things, in my mind, lead to my being here today. I would also say that his statement for "I need a free phone call" would be his invoking of his right to counsel.
Why is that an invocation of his right to counsel?
Yeah, that was my question as well. I mean, I've never had any experience where asking for a free phone call equates to "I want a lawyer." So what's your basis for that?
My client was insistent throughout the 3 years that I represented him, and continued to, that was his uninformed request for an attorney, for a phone call to reach an attorney, for a phone call, for a free phone call that he believed he was entitled to seek counsel. And whether or not that was to call his father, because he did make a follow-up request at the end of the first interview to call his father.
That was 3 hours later.
Right. But perhaps that phone call would have, the second phone call, had he been afforded either one of those calls, would have been to, "I would like an attorney," whether it was to call someone or to his father.
Yeah, and the first one was in regard to trying to see his wife. They weren't going to let him see his wife because they were both involved in the instance, and he just really wanted to see his wife, and that's not the same as a lawyer.
No, and I understand that about wanting to see his wife. What was troubling to me is that the officers that were interviewing him were unfamiliar with Tennessee and perhaps the local practices of how they handle their custodial interrogations or any type of interview. But when at the end of I think it was around 3.5 hours, Mr. Littleton asked again about the phone call, and that officer, the officer that remained in the room, I believe, made a statement such as, "I don't know. I don't know if you're ever going to get that call. I don't know if that's going to happen." And so they were just...
Well, can I ask you something? So he gave 2 more statements after this one, and those statements were initiated. He self-initiated contact with the police.
Yes, Your Honor.
So does that have any bearing in the analysis for the totality of the circumstances for the first phone call?
I believe...
Or for the confession, I'm sorry.
I believe that third interview, I think that the officer testified at the motion to suppress, and please correct me if I'm wrong, but I believe he testified that his reason for speaking with my client, even though my client summoned him, was to obtain consent to use access the telephone. And my recollection is that there wasn't much else substantive in that conversation other than the...
Okay. I guess what I was trying to get at was more so, he didn't want a lawyer. I mean, he didn't ask for a lawyer in those second two instances. He wanted to explain away his circumstance or his involvement with the offense. So, I mean, I just didn't know if you wanted to speak to that, because there were two other instances where he initiated contact with law enforcement.
He did, Your Honor. I think that the most damning evidence in my mind is what was obtained during that first interview and what was primarily utilized by the government during the trial, particularly the opening and closing statements, which I think were very impactful on the jury. I don't know if I've spoken to that, but I would just like to also say that some of the statements that law enforcement did make to him, I think, might go to the feeling of inducement, perhaps, of my client to make those. And so some of the things that law enforcement did make statements to him during these interviews were, you are getting ready to go off a cliff, the truth shall set you free, you're looking at murder, and you should be terrified. And so I think if you do couple those things with the length, as it does, I think in this particular case, cut both ways, the confusion, the possible impairment, and what I would consider as threats or inducements, I think would ultimately indicate that the statements that he did make were not voluntary, that he did not make a knowing waiver of that right. And I would just like to say that Article 1, Section 9 of the Tennessee Constitution, I believe, is more broad and more protective of the individual rights than perhaps the Fifth Amendment's test of voluntariness. And so I would just like to say that
your client was apparently pretty garrulous in his interaction with the officers, and to the point that, as I understand it, there was a time or two that they wished to conclude the interview, and the defendant wanted to keep talking. How do you reconcile that behavior with the claim that he was acting under duress or was involuntary in what he said?
I would just say that once he asked for that free phone call, that all of that should have stopped at that point. Law enforcement should have terminated that conversation at that point. So I would say that once he asked for that free phone call, that the interview should have ceased at that moment. Okay. Such as a bright line, I would say. And also, again, I think some of this could have been cured by some type of test or delay, but the effects of methamphetamine, how much he had been using, the fact that he did inform law enforcement that he had been up that night and perhaps several nights prior to that because of this incident that occurred, this horrific incident that occurred, lasted a long period of time. 14 hours, I believe, is my recollection of the time frame that this victim suffered was over almost an entire day.
The only thing that I'll say, and you're doing a great job. You're doing a great job. I know you're nervous. You're fine. Was it not fair for the trial court to listen to the confession, first statement, and make her determination based off listening to how the defendant handled himself, that he was not impaired? Is that fair?
Yes, it is. And we would just respectfully disagree. And finally, I would just say that the conduct of the law enforcement, the government agent in this case, would be that their behavior overbeared Mr. Littleton's free will so as to invoke his right against self-incrimination, and that the statements that were made at the time during that interview could be seen as an inducement or threats in my mind. And thank you for your time this morning.
Thank you.
Good morning, Your Honors. May it please the Court. Abigail Renard for the state. First, to just address your question about the motion for new trial, I believe that was included in the record.
It is?
I think it's in volume 15. I may be remembering that
You're talking about
incorrectly.
the transcript or the actual motion?
I think it's the actual motion, but I don't remember for sure.
Okay, so I had a couple of different people looking for it, and but we'll double check now that you've said it on the record. I'm sure they're listening. I appreciate that.
There's at least something there. I'm not sure. I don't remember off the top of my head if it's the motion or the transcript, though.
All right, thank you.
Yeah. This court should affirm the defendant's conviction because the trial court properly denied the motion to suppress. The defendant voluntarily spoke with police officers, and he never asked for an attorney. So turning first to the voluntariness issue, the totality of the circumstances here demonstrate that the defendant's statements were voluntary. He was advised of his rights before every interview. He waived them each time. Multiple different officers talked about them. He never asked, excuse me, he never asked any questions, and he never invoked any of those rights. Moreover, he was in his early 30s, he was well educated, had 2 college degrees, he had prior experience with the police, and I believe in the second interview, I don't remember if it was the second or third interview, but one of the officers made a statement along the lines of, you have experience with police, you're on probation, you understand how the system works, right? And the defendant agreed with him. So, and that was in a different interview than the first one, obviously, but it's still relevant, and this court can consider it. None of the interviews were particularly long. The defendant never asked for a break. The officers tried to end it earlier to the point where one of the officers testified that you eventually had to cut off the interviews because the defendant just kept speaking. And in regard to the issue about meth, the only evidence in the record to suggest that the defendant was impaired or was on meth is his own say-so. The trial court explicitly credited the officer's testimony that he was not under the influence, and that finding was well supported. The defendant was very engaged throughout all of his interviews. He answered questions, he was focused, he was trying to talk through all the issues and provide his own attempt at a coherent narrative of events. And this court has held that any defendant who gives a coherent narrative of events, even if they are impaired in some way, it's not to the point where it would render that those statements to be involuntary. Addressing the aggressive statements, the officers explained that when they told him he was going off the rail or off the cliff, they were essentially just saying that his version didn't match his co-defendants, and regardless, the defendant continued to answer questions, continued to engage with them. He never exhibited any signs of being apprehensive or intimidated. He was not timid, and he didn't hesitate to ask to call his wife or ask for his phone call. And in regard to his request for a phone call, that is not a request for an attorney. This court has repeatedly required defendants to unambiguously request an attorney, and the defendant never did. And during the first interview, he told officers that explicitly that he was speaking to them without an attorney for the purpose of making sure that they knew he was being truthful. And if this court has no further questions, we ask that you affirm. Thank you.
Thank you both for your argument this morning. You want?
I'm sorry, I didn't.
You want to take a break? Go ahead.
No.
Call on this case, please.